The second case to be heard today is 240737, Emilio Puente versus Iowa City. Appearing on behalf of the appellant is attorney Peter Sand, and on behalf of the appellee is attorney Elizabeth Craig. So counsel, take your time getting situated. Mr. Sand, when you're ready to proceed.
Honor. Opposing counsel. May it please the court. I have the privilege of standing before you today in representation of Officer Emilio Puente, who served nearly 3 years with the Iowa City Police Force, was commended for bravery during his service, and his law enforcement career was ended by a serious injury that happened November 21st of 21, when his leg was stomped by an arrestee during an arrest, and a nerve was crushed, and he couldn't walk for many months after that and was in a period of uncertainty. A couple of days after that, he was notified that he was to be investigated by the department for a couple of arrests he was involved in prior to his injury. And that resulted in a meeting on February 3rd of 22. That is much of what the case is about. And at that meeting, he was convinced to sign his name to a resignation letter that was placed before him by a couple of union representatives who were there ostensibly to help him with the process. And then later on, after he calmed down, he tried to rescind that letter the following morning. So from these events, after he located us as counsel a few weeks later, from that event, we brought 3 claims in a district court action that is before this court today, distinct claims. One, a claim of wrongful termination in retaliation for making a claim of work injury, what I call a Springer claim, a claim allowed by that Springer case from the late 80s. 2, a claim that he should be allowed to rescind his resignation as given under duress, what I will refer to as a Schultz claim. And then later on in the case, we did assert that he actually did rescind the resignation before it was actually accepted by the city. Now, over a
Stamp date on February 4th?
Yes.
Okay. Thank you.
Over 100 years ago, the legislature of Iowa passed a law that now appears in Chapter 400, creating a right to a hearing on behalf of municipal employees to protect them against arbitrary adverse employment action. It's a very broad category. You just have to show that your treatment was arbitrary. However, the remedy is very narrow. Your request for a hearing must be brought within 14 days. There's no right to discovery in the chapter, and your hearing is before a civil service commission, and your remedy is limited to reinstatement and back pay if you succeed in your claim. Many decades later, state and federal courts and legislatures passed other laws granting rights to seek redress against adverse employment action to employees at large. These remedies tend to be more narrowly described, like a Springer claim, but the remedies are broader. You have your 2-year limitation period. You have a right to discovery. You have a right to a jury trial on damages. So one of the threshold questions in this case is if a municipal employee has a claim for wrongful termination, a Springer claim, can they bring that, or are they required to bring that before the Civil Service Commission, and that's the limit of their remedy? I note that Chapter 400 nowhere says that it's the exclusive remedy for employment issues, but of course, back when it was passed into law, there were no judicial remedies for adverse employment action. So it doesn't say that it's the exclusive remedy, and therefore I don't think it should be considered the exclusive remedy.
Counsel?
Yes, Your Honor.
But didn't the court in Van Ball address that argument that just because the statute doesn't say that it's the exclusive remedy doesn't mean that it's not actually exclusive?
The court did say that. And as Your Honor knows, I argued extensively in my briefing that Van Baale was wrongly decided. Obviously, I'm not here to speak to this court today about those arguments. I do hope the fact that I made those arguments don't detract from or distract from my equally strongly held arguments that Van Baale just doesn't apply to this case. Officer Van Baale was not bringing a Springer claim. He was bringing a claim that the examining courts, district level and appellate level, said they couldn't separate from a claim of arbitrariness, which would come under Chapter 400. So, my main point on the Springer claim is that it does not do violence to Chapter 400 to allow a municipal employee to bring a Springer claim. And in fact, what happens is it does violence to Springer if we're not going to allow a municipal employee to receive the protection that that case was intended to grant to working Iowans. When my yellow light goes on, how much time do I have left?
4 minutes and 13 seconds.
Awesome. We also brought a claim that he should be allowed to rescind his resignation as it was given under duress, our Schultz claim. The Schultz claim was directed out prior to deliberation by a jury. The court held that there was not sufficient evidence showing that the facts in this case were just like in Schultz. So what we see is a sentence from Van Baale being applied to our case regardless of the facts of our case, and yet we have the facts of Schultz being applied to our case despite the broad language of Schultz.
About that duress claim, it seems to me that your client would need to show that his resignation was the product of some action attributed to his employer, correct? Do you agree with that?
I'm not sure I agree with that, Your Honor, and I think I argued that that's not necessarily the case. The record showed that the parties were in separate rooms at the time of this resignation discussion. My client in a room with 2 union reps who were trying to advise him. And
that he was going to be terminated if he did not resign?
not only that, Your Honor, but advised that he would never again work in law enforcement. Now, as subsequent history would show, he couldn't. But at that point, there was still hope he might recover from his injury. So that was part of the message. And, they're in separate rooms. The chief of police has no idea what's going on in this room with these 2 union reps and Officer Puente. So I don't think it's necessary that this would be attributable to the city.
Come from his union reps?
The duress comes from the situation and mostly the complete unknowns as to how a resignation or fighting a termination would affect his ongoing compensation for his work injury, which was disabling at the time. And sure enough, as soon as he handed in that letter of resignation, his ongoing compensation for work injury was cut off immediately. So it's a very heightened duress situation, and we think we made the showing necessary to take that question to the jury.
So I'm just,
Sorry, go ahead, Judge Langholz.
I'm trying to understand, your duress claim is still seeking liability from the city, though, right? I mean, is that what the nature of the claim? You're seeking damages from the city? And if so, like, how could the city be liable for somebody else's conduct?
The duress claim was distinct from the wrongful termination claim, even though the two got intermixed quite a bit during these proceedings below. The wrongful termination claim would be a claim bringing a claim for damages to be argued to a jury. The claim for duress was just seeking to rescind the resignation.
So it's just an equitable claim of some sort?
Yes, a claim that a person should be allowed to rescind some action taken as part of a contract is an equitable claim that the relief should be relief from the contractual consequences of the action taken under duress, Your Honor.
What would be the practical effect if you were successful in that then? I'm just trying to understand how that would play out.
Well, the resignation would have been rescinded, and that would have reinstated employment. Now, the chief could terminate him immediately, and then we would be forced to go through a civil service commission proceeding on the termination.
Counsel, on your rescission claim, can you help me understand? It seems like you kind of changed the claim a little bit after the summary judgment ruling, and at trial made it more into a lack of capacity claim, which the court then directed verdict on. Are you challenging the substance of that decision on appeal, or are you merely looking at the duress issue?
Yes, I am challenging all of it, Your Honors. I am over time. Perhaps I could take that up during rebuttal, or should I finish this? Thank you, Your Honor. My main argument to try and get at what I assert is a Schultz error is that the Schultz case says you can bring a Schultz claim in district court despite the fact that we have over here Chapter 400. And what the district court did in this case is say, well, you know, when you look at Schultz, in addition to saying that, they also said one reason you can do that is because Officer Schultz isn't even arguing that the city had anything to do with this, and therefore he couldn't possibly bring a claim under Chapter 400. So what happened in my case is the district court, you know, thanks to able counsel for the city who made these arguments, said, look, you got to meet the facts in Schultz before we're even going to let you bring this Schultz-type claim. And that's what I argue is the error. I shouldn't have to meet the exact facts in Schultz in order to bring that type of claim in district court. Thank you.
Rebuttal. Counsel, when you're ready.
I'd like to start with what the city viewed the Schultz case as actually holding. The Schultz case was not a duress case at all. And in fact, the Schultz case said that if the officer in that case had alleged that his employer had been responsible for the circumstances that led to his resignation, he would have had to have brought a civil service claim. The Schultz case was actually a pretty straightforward contract case where that officer was saying, I lacked the mental capacity to submit my resignation. It was a contract capacity issue. It had nothing to do with duress, and the court actually said, you could have gone to the Civil Service Commission if you'd made a duress claim. And so I think it's important to clarify that because procedurally, these things sort of happen in stages. At summary judgment, the duress claim was dismissed because the court viewed it as inextricably intertwined with the claims that the court had decided should have gone in front of the Civil Service Commission because that was the exclusive remedy for Officer Puente's claim that he should not have been discharged from the police chief. And so the duress claim didn't exist by the time we made it to trial. What he was left with then was a Schultz claim that Officer Puente claimed was due to his mental incapacity, which then failed on directed verdict.
Counsel, can I have you just jump to the third argument raised by the appellant on this stamp date for February 4th and the allegation that the termination actually occurred on February 3rd? What bearing do you believe that file stamp has?
None whatsoever, because the police chief is vested under Chapter 400 with the authority to discharge Officer Puente. And so the stamp that exists on Officer Puente's resignation letter that Officer Puente argued to this court was legally dispositive was the human resources stamp. But that's not the operative date for when that resignation was actually accepted. You'll see if you look at Defendant's Exhibit A, which is Officer Puente's resignation letter that the police chief wrote February 3rd, 2022, accepted in his own handwriting on that resignation letter, and he testified at trial that I accepted the resignation letter on February 3rd of 2022, which was before Officer Puente attempted to rescind his resignation. I'm going to go back to the exclusive remedy issue because I think that's what the parties devoted most of the briefing to in this case, but I'm happy to address any other issues that come up that the court would like to hear more about. From the city's perspective, this is just a very straightforward case of existing law about the exclusivity of remedies as compared to the common law remedies that are available to a municipal employee. Puente's claim below is that he was constructively discharged in violation of public policy because he was forced to quit his employment at a time when he was receiving compensation for a work injury. And his claim is that while a private employee has a cause of action under Springer versus Weeks, it's only fair that a municipal civil service employee should have the same type of claim available to them. But of course, the key difference here is that Chapter 400 provides a civil service employee an entire administrative process that they are able to go through. And a civil service employee can only be discharged for cause. A civil service employee who is discharged for cause then has Chapter 400 to turn to, which has a lot of protections for a civil service employee. If you look at Chapter 400, you can see all of the ways that that type of employee is protected in the way that an at-will employee would not be. There's a right to an expedited hearing. There's the right to counsel if you are not paid for counsel, obviously, but you have the right to be represented by counsel. There's the right to subpoena records. There's the Civil Service Commission has contempt power. They can be held in contempt. There are remedies that were created by the legislature in response to the creation of the right of the civil service statute that are comprehensive. And when you look at the ensuing case law, it's very clear that when the legislature goes to the trouble to pass a comprehensive statute that creates new rights and remedies as part of that, that those remedies are exclusive. And of course, as Judge Bading pointed out, the Van Bailey case says and recognizes that although the civil service statute itself does not explicitly say it's the exclusive remedy, that because of the completeness of that statute and the creation of new rights and remedies, that it is the exclusive remedy for a civil service employee. The holding of Van Bailey has also been applied repeatedly by the Iowa Supreme Court in different contexts. If you look at cases over the years, as recently as this year, in the Halber case, the Iowa Supreme Court applied the holding of Van Bailey in holding that a whistleblower claim had to be brought under the whistleblower statute. And of course, that's slightly different because that's a statute that's providing a claim, a cause of action in that case, but it's looking to Van Bailey for that same type of concept where if you have a claim that's part of a statute that creates a remedy, that remedy is going to be exclusive to the claimant. Alternatively, and this is as an alternative basis for the court's ruling that the remedy was exclusive, the city made the argument that Puente's wrongful discharge claim also did fail on the merits. Even if this court did find that Puente had a legally viable wrongful discharge claim, we do think it would fail on the merits because the city had voluntarily contended that Puente quit his employment voluntarily, that he wasn't subject to intolerable working conditions simply because he was faced with a rational choice by union employees that you can either quit your employment or we believe as union employees that you will be terminated. And second, the city contended that Puente couldn't generate a genuine issue of material fact on whether his alleged discharge had violated public policy. Although he was receiving medical benefits at the time that he resigned for a work injury, there was no record evidence that connected his receipt of medical benefits to the chief of police's decision related to these course of events. Both of the incidents and the investigations that formed the basis for Puente's termination predated his work injury. When you go back and look at the argument of the involuntariness of Puente's resignation, that argument, as Mr. Sand indicated was based on his duress claim. I think there's also been a little bit of conflation in some of the argument about whether a duress claim is the same as an incapacity claim. I think it's clear from the case law that it's not the same. A duress claim is a duress is a legally defined concept. There has to be action taken against a person who's entering into a contract that is unlawful and that the other party had no reasonable alternative to entering the contract. And so that's not the same as an incapacity claim, which is what we ended up with during trial.
About what's your response to the argument that the duress claim was duress not from the city, and therefore kind of taking it out of the exclusivity bucket?
I don't think the city would belong here at all today if the city's not the party that's responsible for the duress that was the cause of the damage. I think that inevitably would lead to a causation problem that would be dispositive. The only issue, as I said, that actually went to the jury was the issue of whether Puente's resignation was legally accepted, and we talked a little bit about that resignation letter and the significance of the human resources stamp on that letter, which from the city's perspective really was not significant because it wasn't anything that indicated that the police chief had not accepted that resignation letter on February 3rd. In fact, his signature is actually on the letter as of February 3rd. And so under the Haberer case, I think that the evidence was very clear to the jury and supported by substantial evidence, certainly that Puente's resignation was accepted on February 3rd, 2022 by the chief of police. In summary, I think that this was a very well-supported summary judgment ruling by the district court. Some complicated issues that sort of interplayed off of each other, but I think the district court's ruling was legally sound, and its trial rulings were as well, and the city requests that the court affirm.
Rebuttal when you're ready.
Thank you, Your Honor. May it please the court, very briefly on this issue of the file stamp. That key exhibit in the case is the letter of resignation. It's file stamped by the city February 4th. It does have on it some handwriting from the chief saying accepted February 3rd. But if you dig into the record, you will see that the chief never testified that he wrote that on there February 3rd. We did not challenge the fact that he was likely handed that on February 3rd, but nevertheless, the officer is employed by the city. And the city's file stamp says February 4th, and we think that should have some meaning. We just think it ought to be a standard rule of law that a file stamp does have meaning, and that means that's when it was received and accepted. So I'll let that go. Judge Langholtz, on your question about the duress not arising from the city, counsel said, well, then why is the city even here? Well, I would say the city's here because they're trying to enforce the resignation letter. They're trying to get the benefit of that letter as if it's something they can rely on. We are simply suing for a remedy to set it aside because it was the product of duress. And we think the law of contract allows for such a cause of action.
Is it your position that you could not bring that claim before the commission? That you could not have gone to the Civil Service Commission and said, there's no resignation here, this is improper because of duress?
That's a difficult question because there are parts of the city's actions in this course of dealing leading up to that resignation letter that are the responsibility of the city. So it's kind of a mixed question. As an advocate for Officer Puente, I would argue he has a remedy anywhere he can find one. He was injured on the job being attacked by an arrestee, and it ended his law enforcement career, and I think he deserves a remedy wherever he can find it. We did have some record before the Civil Service Commission. That's not in the record in this matter. I could speak to that, but it seems like it would be beyond the scope of what I'm allowed to talk about here.
If that's the case, and I understand your position that there should be a remedy in both places, but isn't the exclusivity principle part and parcel, the flip side of that same coin, that, if you could do it there, then you can't do it here, it has to go there?
I think it's possible that you could be under duress for a reason related to the city management's actions that might possibly be able to be brought before the Civil Service Commission, and you might be under duress from reasons unrelated to the city management, and you ought to be able to seek your contract remedy that's available in district court for that. Now, if you seek both remedies and the findings of fact and conclusions of law in one of those areas closes off your remedy, maybe you've elected your remedy at that point, Your Honor, but that didn't happen here. The other thing I wanted to say is I think it defies logic to say that a statute passed by the Iowa legislature back in the 19-teens somehow preempts subsequent law. I do think that exclusive remedy is conceptually different than preemption, and preemption kind of crept in here, and I don't think it's logical to say that. I don't think Van Bali, and I think we're up to 3 different pronunciations of that case. I have no idea what the correct pronunciation is, but I don't think Van Bali said that Chapter 400 preempts Springer. I think what it said is that Officer Van Bali's specific claim was indistinguishable from someone claiming arbitrary termination, and therefore that was the exclusive remedy. And I also can't help but point out that Officer Van Bali had previously brought a claim in the Civil Service Commission alleging this exact same problem that he alleged in district court, and that remedy went to conclusion, even on appeal to district court. So, I continue to say over and over, and I know that it hasn't been listened to by the judiciary up till now, but I continue to assert that Van Bali is a res judicata thing. It's not really a preemption thing, and I argue it's not exclusive remedy as compared to Officer Puente, who has very different facts and a Springer claim. Officer Van Bali had already gone through his first remedy and had elected a remedy. Thank you very much, Your Honors.
With that, we will consider case 240737 fully submitted and will issue an opinion as soon as possible. Thank you to counsel for your helpful arguments today.